This section of the presentation covers the open meeting law's requirements for accessibility, remote participation, and public participation in meetings. Please note that this presentation is current as of March 2018. Please check with the Attorney General's office to ensure that a more recent presentation has not been published. You can do so by visiting the Attorney General's Open Meeting Law website at www.mass.gov/AGO/open-meeting. Public bodies must ensure that the open meetings are accessible to the public. Access to a meeting must include the opportunity to be physically present, as well as to see and hear what is being discussed by members of the public body. Thus, public bodies must take reasonable steps to accommodate anticipated crowds and must meet in locations that are accessible to persons with disabilities. The Attorney General's Civil Rights Division is available to assist the public in meeting the requirements of laws including the Americans with Disabilities Act, the Federal Rehabilitation Act of 1972, and certain state law provisions. If you have questions about how to comply with any of these laws, please call the Civil Rights Division at 617-963-2939. Finally, though meetings should be held in locations that do not discourage public attendance, public bodies may meet in buildings with security policies intended to ensure the safety of building employees. Note, however, that security policies may not be used as a pretext for unlawfully excluding certain members of the public from open meetings, and our office generally discourages any policy that excludes interested members of the public from a meeting. The Attorney General has authorized the use of remote participation during meetings of public bodies if the practice has been adopted by the appropriate entity. Remote participation should be used as a means of increasing participation in government and not as a means of undermining the spirit of the open meeting law. The Attorney General strongly encourages members of public bodies to physically attend meetings whenever possible. Before members of a public body may participate in a meeting remotely, remote participation must be adopted as follows. For local public bodies, the Chief Executive Officer must authorize remote participation for all public bodies in the municipality. Generally, this will be the Board of Selectmen or the Mayor, depending on the municipal charter. For county public bodies, the county commissioners must authorize remote participation for all county public bodies in the area. For all other public bodies, including state and regional public bodies, a simple majority of the public body members must vote to authorize remote participation, with that vote applying to all subsequent meetings. Local commissions on disability may authorize remote participation through a simple majority vote of the commission's members. These commissions may vote to authorize remote participation for a specific meeting or for all of their meetings and do not need approval by the municipality's chief executive officer. If remote participation has been adopted, public body members can participate in meetings remotely if physical attendance would be unreasonably difficult. There are certain minimum requirements that public bodies must meet when using remote participation during a meeting. The remote participants and all persons present at the meeting location must be clearly audible to each other. Also, a quorum of the body, including the chair, or in the chair's absence, the person authorized to chair the meeting, must be physically present at the meeting location. If a local commission on disability has adopted remote participation, however, only the person chairing the meeting must be physically present at the meeting location. All other members may participate remotely. Members who participate remotely and members present at meeting locations must be clearly audible to each other. Finally, members of all public bodies who participate remotely may vote and shall not be deemed absent from the meeting. If a member of a public body anticipates needing to participate in a meeting remotely, that person must first notify the chair as soon as reasonably possible before the meeting. If the chair determines that the person's physical attendance would be unreasonably difficult, then the chair must announce at the beginning of the meeting who is participating remotely. This information also must be included in the meeting minutes. During a meeting at which a member of a public body is participating remotely, all votes must be taken by roll call. A public body member may participate remotely during an executive session, but he or she must state first at the start of the executive session that no other person is present or able to hear the discussion at the remote location unless the presence of that person has been approved by a simple majority vote of the public body. Whenever feasible, the person chairing the meeting should distribute to remote participants, in advance of the meeting, copies of any documents or exhibits that he or she reasonably anticipates will be used during the meeting. If used during the meeting, such documents are part of the official record of the meeting and must be listed in the meeting minutes. Acceptable methods for remote participation include telephone, internet, or satellite-enabled audio or video conferencing. Any other technology that enables the remote participant and all persons present at the meeting location to be clearly audible to one another is acceptable. Participating by online chat or text message, however, is not permitted. The public body may choose which method of remote participation it wants to use. When a public body uses video technology, the remote participant must also be clearly visible to all persons present at the meeting location. However, the public body is not required to make the entire meeting room visible to the remote participant. If technical difficulties arise during a meeting, the person chairing the meeting may decide how to proceed, but is encouraged, whenever possible, to suspend discussion while reasonable efforts are made to correct any problem that interferes with a remote participant's ability to hear or be heard clearly by all persons present at the meeting location. If technical difficulties result in a remote participant being disconnected from the meeting, that fact and the time at which the disconnection occurred must be noted in the meeting minutes. The open meeting law was meant to ensure public access to the activities of government, but it does not guarantee the public an absolute right to participate in meetings. Members of the public have a right to attend any open session of a public body's meeting. However, the chair has discretion over who may speak during a meeting, and members of the public may not address the body without permission of the chair. We strongly encourage chairs to give the public an opportunity to comment, however, especially where the discussion involves a topic that is controversial or of great public interest. Members of the public have the right to make an audio or video recording of any open session meeting, provided they notify the chair first. Once notified, the chair cannot prohibit a person from recording an open meeting. The chair can set reasonable requirements as to the placement and operation of the equipment so that it doesn't interfere with the conduct of the meeting. If a person informs the chair that the meeting is being recorded, the chair must then inform the other attendees at the beginning of the meeting or when the recording begins. Finally, the chair has the authority to keep control of the meeting. If a person is disruptive, the chair can give that person a clear warning to stop. If that person continues to be disruptive during the meeting, the chair can order that person to leave, even where the disruptive individual is a member of the public body. If the person does not leave, the chair may authorize a police officer to remove the person from the meeting.